There are three kinds of offences in criminal law of UK. The first is summary offence. Summary offences are of least serious nature and most probably one only gets fined in those offences and the punishment doesn't go up to the 6 months or more than 6 months, and it is usually done in the common assault. So when you have proceeded in the magistrate court in a summary offence, you can take guilty plea or not guilty plea. If you take guilty plea, the court will proceed to sentence, and if there is any dispute as to the factual basis upon which defendant will be sentenced, the court may have to hold a Newton hearing. Sentence may be passed immediately or adjourned for the preparation of pre-sentence report. And if you take non-guilty plea, the court will set a trial date and do any necessary case management to ensure that trial is effective on the date. The parties must complete a case management from setting out what the issue at trial will be and where witnesses are required to give live evidence. There is a connection between 2 points. A court must actively manage a case to ensure that only those witnesses whom the defense want to challenge on their evidence come to the court. So the witnesses that the defense doesn't challenge will not have to come to the court, because that kind of stuff will waste only the time of the court. The court should set a timetable for trial and estimate how long the trial will take. Magistrate court are encouraged to scrutinize with utmost vigor any time estimates in excess of day for a summary trial. Where a case has been set down by a summary trial, the court can conduct pre-trial hearings at which pre-trial rulings can be made. These can cover matters such as admissibility of the evidence and fitness to plead. Rulings can be made on the application of the defense or prosecution of the court's own motion. The pre-trial hearing is binding until the case is disposed of by conviction or acquittal of the accused, or by prosecution decision not to proceed, or by dismissal of the case. The court can, however, discharge or vary a pre-trial hearing if it is in the interest of justice to do so, and parties have been given an opportunity to be heard. A party can apply to have pre-trial ruling varied or discharged only if there has been material changes of circumstances.